Welcome to Real Estate Salespersons, aka RES, Exam Prep, the deep dive that equips you with the knowledge you need to conquer the Singapore RES exam. You send us your study materials focusing on the sale of uncompleted private properties, and together with Damien, our in-house expert, we're going to unpack the essential elements you absolutely must know.
Great to be here.
Our mission today is simple: cut through the complexity and arm you with a clear understanding of this crucial area. Think of this as your personal shortcut to exam success. We'll highlight the key regulations, processes, and potential pitfalls, maybe with a bit of humor to keep things engaging. So let's dive into the world of new home sales by developers.
Thanks. Yeah, it's great to be back. What's fascinating right off the bat is that buying a place that's still just blueprints and, a construction site, it's a whole different ballgame compared to picking up the keys to an existing condo.
Oh, completely.
We're talking about a different set of rules, almost like the difference between ordering a custom-made suit versus buying one straight off the rack.
Exactly. It's not like haggling over the price of a pre-loved coffee table, is it? Okay, let's unpack this. When we talk about developers selling new homes, especially residential ones, they're playing by the rules of the Housing Developer Control and Licensing Act and its sidekick, the Housing Developer Rules.
Right.
Now, if we're talking about shops or offices, commercial properties, there's a separate playbook, the Sale of Commercial Properties Act and its rules. Think of it as knowing whether you're reading the highway code or the maritime regulations, different situations, different rules.
That's a fundamental distinction for anyone prepping for their RES exam. Seriously.
Yeah.
Knowing which act applies residential versus commercial is practically a free point waiting for you.
Couldn't agree more. Now, let's zero in on the Housing Developer Control and Licensing Act and rules, because this is often where the exam likes to throw a curveball. What's the absolute first thing a developer planning a new condo needs to sort out before they even think about bringing the bulldozers?
Well, if a developer is dreaming of a residential project with more than 4 units, and let's face it, most aren't just building a cozy little row of terrace houses, they absolutely must get a housing developer's license from the big boss, the controller of housing.
Before anything starts.
Before any construction even kicks off. It's like needing your pilot's license before you can even taxi a jumbo jet. There are 2 main flavors of these licenses. A sale license, which gives them the green light to build and sell once their building plans are approved.
Okay.
And a no-sale license, which only allows them to build. If they've got the no-sale version, they need to get special written permission from the controller before they can even think about putting up a for sale sign.
Oh, okay. So it's not a build it and then hope people show up with their checkbook situation. There's a whole process to follow. And what's the grand purpose behind all this bureaucratic hoop jumping?
The whole shebang, the Housing Developer Act and its rules, is designed to make sure things are fair and square when you're buying an uncompleted private home. It's like having a referee in a football match. The rules are there to protect you, the potential buyer, and to stop developers from, shall we say, scoring any unfair goals with your money and leaving you with a half-finished stadium.
That analogy works. So once a developer gets this license, is it valid indefinitely? Or does it have an expiry date like, I don't know, a carton of milk?
Good question. A housing developer's license isn't a lifetime VIP pass. It expires once the project hits 2 key milestones. First, when the Commissioner of Building Control gives the thumbs up with the certificate of statutory completion, that's essentially the all clear that the building is structurally sound and safe. No wobbling balconies allowed.
Right.
Second, it expires when the Registrar of Titles issues the certificates of title or subsidiary strata certificates of title, which officially confirms who owns each individual unit. Once those 2 boxes are ticked, the developer is no longer under the purview of this particular act and its rules for that specific, now completed project.
Okay, so license needed for bigger projects, 2 types for selling or just building. It's all about fair play, and it expires once the building is certified safe and ownership is clear.
Got it.
Now, you mentioned some crucial must-knows under this act for our listeners who are, sweating over their RES exam. What are the headline requirements?
Right, so for your exam, nail these points. 1, the need for a license for any residential gig with more than 4 units is non-negotiable.
Okay.
2, developers can't start selling until they've got both that sale license and their building plan approval stamped and ready. It's a 2-step tango.
Right, both.
3, and this is a biggie for buyers, and therefore for your exam, they absolutely must use the government-prescribed standard forms for the option to purchase, OTP, and the sale and purchase S&P agreement. No DIY contracts allowed, ensuring everyone's on the same page.
Crucial.
And 4, all the moolah you fork over as a buyer before you get the keys at the temporary occupation permit, TOP stage, goes into a special pot of gold called a project account.
Ah, the legendary project account. It conjures up images of a heavily guarded vault. Tell us more about this financial fortress.
You're not far off. The project account is indeed mandatory for licensed developers undertaking housing projects. Think of it as a dedicated escrow account at a bank or financial institution where all the cash related to the project gets deposited.
Okay.
This includes your initial booking fee, any construction loans the developer takes out to fund the building, and even the installment payments you make as the construction progresses, right up to the top P stage. It's all in there.
So it's not just the developer's regular business account, where they might also be buying office supplies and, I don't know, planning their next holiday party.
Definitely not.
There are strict rules about what they can use this money for, right?
There's precisely. Developers can't just raid this project account for anything that tickles their fancy. The withdrawals are very strictly controlled and permitted only for specific purposes directly related to the project.
Like what, for example?
Well, we're talking about things like paying the annual property tax on the land, the stamp duty on any mortgages they take out for construction, the legal eagles fees for the sales and mortgages, and the fees for the brains behind the project, the architects, engineers, and other consultants. Of course, the actual hard costs of building the foundation work, digging in the ground, soil investigation, and paying the contractors who are actually laying the bricks and pouring the concrete all come from this account.
Makes sense.
Even connecting utilities, paying government charges, and refunding booking fees if a sale falls through are covered. There's even a little wiggle room for administrative expenses like marketing and advertising, but that's capped at a strict 5% of the total construction cost.
Only 5%. Okay.
And let's not forget the goods and services tax, GST, related to the project. That can also be paid from this account. Finally, in specific situations like with executive condominiums, any forfeitures or refunds might also flow through this account. It's a very, very tightly regulated system designed to ensure your money goes towards building your home.
Wow, that's a pretty comprehensive list of where the money can go. It definitely sounds like a system designed to give buyers peace of mind. Now, let's rewind a bit to that initial step, the booking fee. What's the deal with that?
Okay, so when you, as an eager potential buyer, find a new development that catches your eye, you'll typically put down a 5% booking fee to the developer.
5%.
In return for this show of commitment, you get the prescribed standard option to purchase. Think of it as putting a reserved sign on the unit while you get your ducks in a row sorting out your financing and, poring over the paperwork.
And as you've highlighted, this all comes with a non-negotiable standard OTP and S&P agreement.
Yeah.
Why is it so crucial that these documents are standardized across the board?
Well, the mandatory use of these standard forms is really a cornerstone of the Housing Developer Act and rules. It levels the playing field and shields buyers by establishing clear and consistent terms and conditions for all new private residential property sales. It significantly reduces the risk of developers slipping in sneaky, unfair clauses or using confusing, ambiguous language. It's all about transparency and protecting the less legally savvy among us.
Right, no surprises lurking in the fine print.
Yeah.
Okay, so you paid your booking fee, you've got your standard OTP, fast forward a bit, you've signed the sale and purchase agreement. Eventually you get the keys to your brand new abode, right?
Hopefully.
But what if the reality doesn't quite match the glossy brochure? What if something's not up to scratch?
That's where the defect liability period swoops in to save the day. The developer is legally bound to provide a 12-month period starting from the date you receive the golden ticket, the notice of vacant possession.
1 year.
During this year, they are on the hook to fix any defects that pop up in your unit, the entire housing project, or even in the common areas. And the best part, they have to foot the bill themselves.
So if I move in and discover my state-of-the-art kitchen tap is more of a dribbler, or there's a mysterious crack snaking across my living room wall, I can just give them a call.
Absolutely. And if they decide to play hide and seek and fail to rectify the defect within 1 month after you've officially told them about it, the rules actually empower you.
Oh, wow. So
You can then issue a formal 14-day notice stating your intention to get the repair work done yourself and providing an estimated cost. After that 14-day countdown, if they still haven't acted, you can go ahead and get the work done by someone else.
right.
And here's the kicker. You can then claim that cost back by deducting it from the funds that are still being held by the Singapore Academy of Law, SAL, as a stakeholder for the developer.
Okay.
It's a safety net to ensure those pesky defects are actually taken care of.
That sounds like a pretty robust system for protecting buyers.
Yeah.
Now, let's talk about how the payments actually work after you sign the S&P. You mentioned it's not one big lump sum.
Correct. The purchase price is broken down into a series of installment payments that you, as the buyer, make as the construction of the property reaches different stages. These milestones and the corresponding payment percentages are all clearly laid out in the standard S&P agreement.
Right, in the agreement.
And these payments are known as progress payments. And just to reiterate, all these payments you make up to the point you receive the temporary occupation permit, TOP, go straight into that trustee project account we discussed earlier.
Okay, so it's all tied to tangible progress on the construction site. That seems like a fair and transparent way to do things.
Yeah.
Can you give us a quick rundown of what these construction stages typically are and roughly what percentage of the total price is due at each step? This will be super helpful for our listeners prepping for their exam.
Certainly. So when you first sign on the dotted line with the option to purchase, you've already put down that initial 5% booking fee.
Right, the 5%.
Then, when you sign the sale and purchase agreement, which usually happens within 8 weeks of getting the option, you'll need to cough up another chunk of cash to bring the total paid up to around 20% of the purchase price, minus that initial 5%.
Okay, up to 20%.
After that, the payments are directly linked to the building's progress. For instance, once the foundation work is completed, that typically triggers a 10% payment.
10% for foundation.
Another 10% is usually due when the reinforced concrete framework of your specific unit is finished. When the brick walls are up and looking sturdy, that's another 5%.
Okay.
The same goes for when the roof or ceiling is in place, another 5%. Then you'll likely have a 5% payment when the electrical wiring, internal plastering, plumbing, and the frames for your doors and windows are installed.
5% for those internals.
Another 5% is often tied to the completion of the car park, roads, and drainage serving the entire project. The big moment comes when the notice of vacant possession, TOP, is issued and you finally get your hands on the keys. That's usually a significant 25% payment.
25% at 20p. Okay.
And finally, upon the completion date, which is when the certificate of statutory completion is issued, the remaining 15% becomes due. However, there's a slight split here. 2% goes directly to the developer.
Just 2%.
And the final 13% is held by the Singapore Academy of Law, SAL, as stakeholder until all the individual property titles are finalized.
13% held by SL. Wow, that's a really clear breakdown. It's fascinating how the financial milestones are directly linked to the physical building taking shape. But what happens if the developer encounters delays and takes longer than the agreed-upon time frame to complete the project? Life happens. Construction can be unpredictable, right?
Absolutely, delays can occur. And the standard S&P agreement has provisions for this. If the developer fails to issue a notice to complete by the deadline specified in the agreement, they become liable to pay you, the purchaser, what are known as liquidated damages.
Liquidated damages.
Think of it as a pre-agreed compensation for the delay. This is calculated at a rate of 10% per annum on the total amount of installments you've paid up to the date the notice to complete is finally issued. It's a way to provide some financial redress for the inconvenience and, well, the waiting.
Okay, so there's a financial incentive for the developer to stick to the schedule. Now let's flip the coin. What happens if it's the buyer who drags their feet and is late with their payments?
Yes. If a purchaser fails to make any installment payment within 14 days of the date it's due according to the progress payment schedule, they will be charged interest on the outstanding amount.
Interest kicks in after 14 days.
Yes, and this interest is calculated on a daily basis at a rate of 2% above the prevailing base rate. Furthermore, if the payment continues to be overdue, the developer has the right to issue a formal 21-day notice stating their intention to cancel the sale and purchase agreement.
A 21-day warning.
Exactly. If the purchaser still doesn't cough up the outstanding amount within those 21 days, the developer can consider the agreement as having been repudiated by the buyer.
Ouch, those sound like pretty serious consequences. What exactly happens to the buyer if the agreement is canceled due to their late payment?
The repercussions can be quite significant, yeah. Firstly, the developer has the legal right to resell or otherwise dispose of the property as if your original agreement never existed.
They could just sell it to someone else.
Yep. Secondly, they can recover any unpaid interest that has accrued on the overdue payments from the installments you've already made. And perhaps the most financially painful consequence is that the developer can forfeit and keep 20% of the total purchase price, excluding any interest you've paid, from the installments you've previously paid.
Forfeit 20%. Wow.
So staying on top of those progress payments is absolutely crucial.
Definitely sounds like a situation best avoided. Now, what if there's a discrepancy in the actual size of the unit once it's finally built compared to what was promised in the agreement? Sometimes things aren't exactly as advertised.
Good point. This is where the clause addressing errors, omissions, and misdescription comes into play. Once the unit undergoes a final survey upon completion, if the actual area turns out to be different from what was stated in the sale and purchase agreement, there might be an adjustment to the purchase price.
Okay, so the price can change.
Potentially. However, there's a bit of leeway built in a tolerance of up to 3%. If the deficiency in size is 3% or less than what was agreed upon, there's no price reduction.
Ah, a 3% buffer.
Exactly. But if the shortfall exceeds that 3% threshold, then the purchase price will be reduced proportionally based on the per square meter rate for the area that's over and above that initial 3% difference. It's a mechanism to ensure you get what you paid for, within a reasonable margin of error.
It seems like a sensible way to handle minor variations. Now, there's been quite a bit of buzz about new rules regarding restrictions on reissuing options to purchase. What's the lowdown on that?
Yes, this is a relatively recent development that came into effect on 28 September 2020. The Controller of Housing has introduced new conditions attached to the sale licenses issued to developers,
Okay.
specifically restricting them from reissuing OTPs for the same unit to the same buyer within a 12-month period after the expiry of the original OTP.
12 months. That's quite a significant restriction. What's the rationale behind this new rule? What problem was it trying to solve?
Well, the main aim, spearheaded by the authorities, particularly the URA, was to put a stop to a practice that was thought to be artificially inflating the reported figures for private home sales.
Inflating figures. How?
Some buyers were essentially getting a continuous stream of extensions on their OTPs without actually committing to the purchase or facing any real financial penalty for letting the option lapse. This could go on for a considerable amount of time, sometimes stretching to a year or even 18 months.
Wow.
This practice wasn't really fostering financial prudence among potential buyers either.
So it's like a never-ending maybe without any real consequence.
Mm.
And what are the standard terms of an OTP now? What's the typical window a buyer has to make a decision?
Under the standard OTP, once the sale and purchase agreement and the all-important copies of the title deeds are delivered to the buyer, the option period typically lasts for 3 weeks.
3 weeks.
Within this 21-day window, the buyer needs to make their decision, sign the S&P, and return it to the developer to exercise the option. If they fail to do so within this time frame, they risk forfeiting 25% of their initial booking fee.
25% of the booking fee.
Which, since the booking fee is usually 5% of the total sale price, works out to 1.25% of the overall home price. So it's a gentle nudge towards making a timely decision.
That 3-week window sounds reasonable for most situations.
Yeah.
But what if a buyer genuinely needs a bit more time, perhaps because they're in the process of selling their existing property to finance the new one?
Right. The controller does acknowledge that there can be legitimate reasons why a buyer might need a little extra time. In such situations, either the buyer or the developer can apply to the controller for an extension of the OTP's validity period.
Ah, an extension is possible.
Yes, the controller is prepared to consider granting an extension for up to a maximum of 12 weeks from the original OTP date. However, this isn't an automatic rubber stamping process. It requires mutual agreement between both the buyer and the developer, and crucially, it's subject to the controller's approval, which is assessed on a case-by-case basis.
Case by case.
So you can't just expect an extension. You need a good reason, and the controller's okay.
So it's not just a simple request. What kind of information would the URA typically want to see when they're considering such an extension application?
If you're looking to apply for an extension, you'll need to put together a formal application to the URA. This should include a copy of the original OTP, clearly state its original expiry date, and most importantly, provide a detailed explanation outlining the specific reasons why you need more time to exercise the option.
Need to justify it properly.
Exactly. Supporting documentation might also be helpful, for example, if you're waiting on the sale of your current property.
And what are the practical implications of this new 12-month restriction on reissuing OTPs, especially for upgraders? It sounds like it could make navigating the additional buyer's stamp duty, ABSD rules, even trickier.
You've hit the nail on the head there. Upgraders often find themselves in a tight spot. Ideally, they'd want to secure their new home before selling their existing one to avoid being, well, homeless in the interim.
Right, the transition.
However, the ABSD rules add a layer of complexity. Currently, Singapore citizens buying their second property have to pay a significant ABSD. It was 12% of the purchase price, though rates do change. While there's a possibility of getting a refund if they sell their first property within a specific time frame, usually 6 months,
Wow.
this time frame starts from the date of exercising the OTP. With new restriction on reissuing OTPs, upgraders can no longer rely on repeatedly extending the option period to give them more breathing room to find a buyer for their current home.
That makes it tough.
It's a delicate balancing act. It's risky to sell their existing place before securing a new one, but it's also challenging to find a buyer for their current property within that tighter time frame after booking a new development. If they can't sell in time, they might be stuck paying the hefty ADSD, which can be a significant financial burden.
Yeah.
Or, alternatively, they might be forced to let the OTP for their new dream home lapse, losing a portion of their booking fee. And to top it off, they wouldn't even be able to try and buy the same unit again for a whole year. It's definitely added a significant hurdle for upgraders.
That certainly adds a layer of complexity to the upgrading process.
Wow. Now, shifting gears slightly, what kind of information are developers legally obligated to provide to potential buyers right from the start, even before they sign the OTP?
Transparency is the name of the game here. Developers are required to furnish intending purchasers with properly scaled floor plans of the specific unit they're interested in.
Scaled floor plans, okay. As well as a clear and a comprehensive breakdown of the total unit floor area. This must include any external spaces like balconies or aircon ledges, so there are no hidden surprises about the actual usable space.
Good to know about the ledges.
Definitely. Furthermore, if the developer has set up show flats to give potential buyers a feel for the layout, they are also obligated to clearly mark any walls, partitions, or doors that have been removed or are not part of the standard unit design.
Oh, so they have to show what's not included.
Exactly. This ensures that what you see in the show flat is an accurate representation of what you'll actually be buying. No more illusions created by clever interior design tricks.
Good to know. So we've delved deep into the world of residential properties. What about commercial properties? Are the rules a whole different universe?
While there are some overlaps, there are indeed important distinctions. Under the Sale of Commercial Property Act and rules, developers selling commercial properties also have to use government-prescribed standard contract forms for their sales agreements.
Standard forms for commercial, too.
Yes, but a key difference is that commercial property developers are not required to obtain a housing developer's license like their residential counterparts.
No license needed.
Instead, their main regulatory hurdle before they can start selling any units is to obtain building plan approval from the URA. Selling commercial properties without this crucial approval is a serious offense under the Act. So while the licensing framework is different, there's still a significant regulatory checkpoint they must pass before they can put their commercial units on the market.
Okay, so no license needed for commercial, but that building plan approval from URA is their equivalent of a permission slip. What about some of the other key aspects we've discussed for residential properties, like booking fees, what happens if you don't go through with the purchase, and those project accounts? Are those handled similarly?
Not exactly. There are several key differences that are particularly important for your RES exam. Firstly, while the booking fee for residential properties typically falls in the 5–10% range, for commercial properties, there's a cap. It cannot exceed 10% of the purchase price.
Max 10% for commercial booking.
Right. Secondly, if the buyer decides not to proceed after taking the option, the financial consequences are also different. For residential properties, you typically forfeit 25% of the booking fee. Whereas for commercial properties, it's a more significant 50% of the booking fee that you could lose.
50%.
Ouch.
Yeah. The structure of progress payments is generally similar, with around 10 progressive stages for both types of properties. However, the final progressive payment differs. For residential, it's 15% of the price, with 2% to the developer and 13% held by SL.
Okay.
For commercial properties, the final 10% payment is split differently, 2% to the developer and 8% held by SL.
2% and 8% for commercial.
And perhaps most notably, those project accounts, which are mandatory for all licensed residential projects, are not mandatory for commercial property developments.
No mandatory project account for commercial.
Correct. This means there isn't the same level of legally enforced ring fencing of funds for commercial projects. Those are some really crucial distinctions to keep in mind when dealing with commercial versus residential properties. It sounds like the regulations for commercial properties offer slightly less stringent financial protection for buyers in some areas. Interesting. Now, let's move on to the concept of a subsale. What exactly does that term mean in the context of property?
Okay, in simple terms, a subsale happens when someone who has agreed to buy a property but hasn't yet become the legal, registered owner, sells their right to purchase that property to someone else.
Selling the right to buy.
Exactly. Imagine this. Developer A agrees to sell a condo to original purchaser B. Before the actual sale between A and B is legally completed, original purchaser B then finds someone else, sub-purchaser C, who wants to buy that same condo and agrees to take over B's position in the deal.
Huh.
The sale from B to C is the subsale. In this scenario, original purchaser B doesn't yet hold the official title to the property. They only have a beneficial interest, the right to complete the purchase.
So it's a bit like flipping a concert ticket. You bought it, but before the actual event, you sell your ticket to someone else, hopefully for a profit. Was this a common tactic in the property market?
Yes, subsales used to be quite a popular strategy, especially when the property market was experiencing rapid price growth.
In a hot market.
Precisely. The original purchaser could put down a relatively small initial deposit, secure a desirable property, and then quickly find a sub-purchaser willing to pay a higher price. This allowed the original purchaser to potentially make a profit without ever having to fully complete the initial purchase or, take out a mortgage. It was seen as a way to capitalize on rising property values in the short term.
Right, quick profit potential. And how does this sub-sale process work specifically when the property in question is still under construction, an uncompleted property?
Okay, let's break down the steps for a subsale involving an uncompleted property. First, the original purchaser, let's call them OP, pays the standard booking fee, usually 5%, to the developer D, and receives the first option to purchase. We can call it OTP 1.
Okay, OP gets OTP 1.
Now, here's a critical point for your exam. The OP is not legally entitled to subsell the property until after they have actually exercised this first OTP.
Must exercise first.
Correct. Once they do exercise OTP 1, which typically involves signing the Sale and Purchase Agreement 1, S&P 1, that they receive from the developer within a certain time frame, usually 3 weeks, though sometimes it can be extended to 8, then they can proceed with finding a sub-purchaser, SP.
Okay.
If they find one, the OP will grant a second option to purchase, OTP 2, to the SP. It's important to note that the second OTP won't be in the same prescribed Form B that's used for completed properties with a specific subsale clause.
Different form.
Yeah. Instead, it will look more like a regular option for a completed property, but will include clauses that specifically address the subsale arrangement.
So the paperwork for that second option is a bit different, reflecting the nature of the transaction. What about when the sub-purchaser's lawyer needs to do their due diligence? Who do they deal with?
Good question. The sub-purchaser's lawyer will still conduct all the usual checks on the property title, perform the necessary legal searches, and raise any relevant inquiries or requisitions. However, in this subsale scenario, any objections or questions they have will be directed to the original purchaser, OP, not directly to the developer, D.
To the OP, not the developer. Why is that?
This is because, at this stage, there isn't yet a direct legal contract, no privity of contract, as the lawyers like to say, between the sub-purchaser and the developer. The SP's legal relationship is still with the OP, who is selling their rights under the original agreement.
That makes sense. The sub-purchaser is essentially stepping into the original buyer's shoes. How does the actual legal transfer of ownership eventually happen so that the sub-purchaser becomes the rightful owner once the property is completed?
Okay, the conveyancing process for the second OTP will be similar to a regular sale of a completed property, but with some important differences to account for the fact that the property is still under construction.
Right, it's not finished yet.
Exactly. The completion account will need to factor in any progress payments that the original purchaser has already made to the developer, as well as any outstanding payments that are still due according to the original S&P agreement with the developer. Crucially, the original purchaser will legally transfer all their rights and obligations under the original sale and purchase agreement, Agreement 1 with the developer, to the sub-purchaser through a formal legal document called a deed of assignment.
Deed of assignment.
Following this assignment, the sub-purchaser will then enter into a new direct sale and purchase agreement with the developer. To ensure everything balances out financially, the original purchaser will issue a formal instruction to the developer to credit all the progress payments they've already made towards the purchase price to the sub-purchaser's account under this new agreement.
So once all that paperwork is signed and the deed of assignment is in place, the original buyer is essentially out of the picture.
Pretty much. The original purchaser has a key final step. They must obtain the developer's formal consent for the subsale to go ahead and specifically request the developer to issue that fresh, new sale and purchase agreement for the sub-purchaser to sign.
Developer consent is needed.
Absolutely. Once this new agreement between the developer and the sub-purchaser is in place, the original purchaser's involvement in the transaction effectively ends. The remaining stages of the property sale, including all future progress payments, the handover of the keys, and the finalization of the title, will then be conducted directly between the developer and the sub-purchaser.
Okay, we have covered an absolutely massive amount of ground today, from the initial licensing and the crucial project account to the intricacies of defect liabilities, the new OTP restrictions, and the often complex world of subsales for uncompleted properties.
Here.
Damien, any final words of wisdom for our listener as they continue their preparations for the all-important RES exam?
Well, what's truly fascinating about this area, I think, is the comprehensive framework of regulations designed to safeguard purchasers in what is often one of the biggest financial decisions of their lives.
For sure.
Understanding the meticulous flow of funds through the project account and the robust protections offered by the standard sale and purchase agreement are absolutely key takeaways for your exam. And remember, always keep those crucial differences between the regulations for residential and commercial property sales firmly in mind.
Yes, those comparisons.
Right. And this raises a really important question for you, our listener, to ponder as you study. How do all these intricate regulations working together ultimately contribute to maintaining market confidence and protecting the interests of both property buyers and the overall integrity of the Singaporean property market? It's something we're thinking about.
That's a fantastic point to reflect on. We sincerely hope this deep dive into the sale of uncompleted private properties has provided you with the clarity and the confidence you need as you gear up for your RES exam. Remember, as with all things legal and regulatory, the devil is often in the details, so do make sure you revisit these concepts and perhaps even, create some flashcards to solidify your understanding.
Definitely good advice.
We are all here wishing you the very best of luck in your upcoming RES exam. Go out there and absolutely ace it.